All right, I will call to order the Zoning Board of Appeals meeting for Wednesday, May 14th, 2025. To all persons interested in or affected by the action of the Zoning Board of Appeals, you're hereby notified pursuant to Section 11 of Chapter 48 of the General Laws of the Commonwealth of Massachusetts and all amendments thereto, that a public hearing on the following appeals will be held today, Wednesday, May 14th, 2025. We will start with an introduction of board members. Herb Bodensee is absent. Paul Pinard.
Here.
Mark Hanson.
Present.
Aaron Webb is absent. Larry Hurwitz is absent. Manny House.
Here.
Rodney Tavano. Yeah. Natalie Pittenger.
Here.
And I'm Jacob Dewey. Notice of recording this meeting of the Zoning Board of Appeals is being recorded and broadcast on the Town of Barnstable's Government Access Channel in accordance with MGL Chapter 30A, Section 20. I must inquire whether anyone is recording this meeting, and so to please make their presence known. Seeing none. First item, we had some minutes from January 8th, 2025. I think you had some amendments. Someone had an amendment to it last time, is that right? Are we all in agreement to them? Someone want to make a motion to approve?
I'd make a motion to approve the minutes. Second.
All those in favor?
Aye.
Aye.
All right, so those are approved. So our first order of business is another executive session to appeal number 2023-010, Arista/Wendy's LLC, executive session for the purpose of discussing litigation strategy with respect to the case in Land Court 24 MISC 00088 by Arista/Wendy's LLC for the property at 715 West Main Street, Hyannis, originally appealing the denial of a special permit to construct a drive-through window at a Wendy's fast food restaurant, then appealing the grant of the special permit with conditions upon remand order by the Land Court, and the filing of a complaint for contempt against the ZBA for the remand special permit conditions. If the chair determines that an open session could be detrimental to the board's and town's litigation position, we will go into executive session. So I will make the declaration that an open meeting discussion will have a detrimental effect on litigation position of the ZBA, and we'll need a second that we convene an executive session under General Law, Chapter 38, Section 21A3, to discuss this litigation, Arista/Wendy's LLC versus the Town of Barnstable Zoning Board of Appeals at 715 West Main Street, Hyannis, based on this declaration that it will have a detrimental effect. I need a second.
Second, Paul.
All those in favor?
Aye.
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 David, we're going to go in executive session for a few minutes. All right. The zoning board of appeals meeting for May 14th, 2025 is back in open session. Appeal number 2024-039, 25 Falmouth Road LLC has filed an appeal of administrative officials' decision in accordance with MGL Chapter 48, Section 7, 8, and 15, and Section 240-88 of the Barnstable zoning ordinance. The appellant is appealing the decision of the building commissioner in issuing building permit BLDC 22-227 dated September 17, 2024. The permit was initially denied pending the receipt of a narrative to explain the expansion of the mechanical bays on the property. The appellant's position is that the permit fails to take into account evidence and documentation from the town records and files which conflict with the determination to issue the building permit. The subject property is located at 95 Falmouth Road, Hyannis, Mass., as shown on Assessor's Map 311 as parcel 073. It's located in the Highway HB and Residence RB zoning district. This has been continued from November 13th, 2024, January 8th, 2025, February 12th, 2025, and April 9th, 2025, and no members have been assigned. I believe Attorney Ford, if you want to give us an update before we assign members.
Sure. There has not been a resolution between the parties. I can give you that update. So the appeals are still active at this point. There is a threshold question that my brother counsel has raised as to whether or not my client has standing to bring the appeal to the ZBA. And there have been memos filed with the board by both sides on the standing issue. And I know that my brother counsel has requested that the board seek the advice of the town attorney's office as to whether or not you should proceed with a factual hearing or simply make some findings with respect to standing. I have no objection if the board decides in their wisdom to seek advice of the town attorney's office before proceeding with a hearing on this matter. Standing is a question. I understand that. Have briefed it on my side, but that may be a threshold question the board wants to address. That applies not only to this appeal, but also to the next appeal. Factually, they're similar appeals. And if you have a hearing, my suggestion would be, Mr. Chairman, that you treat them together as one factual hearing.
And we did reach out to the town attorney, but we did not receive any response on this. Is Jim still here? Did Jim leave? No, Jim's gone. Anna, I mean, how do you feel that we should proceed? Or Building Commissioner Florence is here too. He might speak to this as he's been involved.
Good evening, Mr. Chairman and members of the Zoning Board of Appeals. I concur with Attorney Kenny that we should probably have a look at this through legal department regarding standing.
Okay.
That's my recommendation. Thank you.
So, Attorney Ford, you're agreeable to continue this? And Attorney Kenny?
I am if the decision is to seek some advice from the town attorney's office. I think that's probably sound for the board members to get that before you proceed.
Okay. Anna, what do you think for timeline? I don't know who's working on this now. I mean, we've continued it since we've assigned extensions.
We have provided extensions so that you're not
There's a timeline, a time extension.
you're not in a concern. Maybe Mr. Attorney Kenny wants to address it as well.
Yeah, Mr. Chairman, if I may make a suggestion, I would suggest we open the hearing, assign members, hear the testimony on the jurisdictional matter, and then refer it to the town attorney, as opposed to, right now, there's only our filings before you. This isn't even opened. So I would prefer to get members assigned, open it, and then get it to the town attorney. If your preference is to simply send it to the town attorney, that's fine with me, but just an alternative suggestion.
Okay, thank you. What's the pleasure of the board?
I worry, given the upcoming summertime and vacation and conflicts and so on, if we assign members and some of the members can't, for some reason, sit on the date that this is reheard, then we're going to have to do Mullins's, and I'd rather not leave it without assigning members would be my preference.
Mr. Chairman, I would disagree with Attorney Kenny on opening it up for a hearing, because I think once you get going and put in a case, I believe my case on standing will be the case on the merits as well. So, because I think, I don't see how you can separate them.
Okay. I mean, is there no sort of thoughts? I'm inclined to just continue it and keep it clean and fresh.
Or refer to town attorney.
Yeah.
Continuance or just?
We're going to continue until we hear back from the town attorney on standing here.
It has to be to a date certain.
Yeah, so I think
and
we would. I
You
think
might
we
want
should
to
put it out a
reference
month
both of them.
right now. We'll continue both of them to the June 11th, or yes, June 11th. Do you think maybe?
I would go further.
Okay,
June
June
25.
25th. Or what's our July meeting?
Do you remember?
I prefer June 25th, to be honest with you. June 25th.
The 9th and the 23rd in July.
Oh, you're looking at July now.
I mean, Anna, you know more of what's happening with the inner workings of the legal department. What do you think we need to go that far?
Why don't we shoot for the second meeting in June
Okay.
in hopes that they'll have hired in another attorney?
What's the date of that second meeting?
25th.
June 25th, it's remote.
That's remote.
Apparently, that's a remote meeting.
Yes.
I don't have an objection with that. Maybe Attorney Kenny does.
That'll be fine.
Okay. So I'll make a motion to continue appeal number 2024-039 and appeal number 2024-040 to June 25th, 2025.
Second.
All those in favor?
Aye.
Aye.
So that, those two items are continued.
Thank you.
Thank you.
Thank you, Mr. Chairman.
Ask them to turn the heat down here, too.
All right, moving on, appeal number 2025-007. Victoria McCloskey, Cynthia Foster, and Mary Curry have filed an appeal of an administrative official's decision in accordance with Chapter 240-91, non-conforming lot on,
Excuse me, Mr. Chairman. Are we doing Clark?
oh, did I skip that one?
Yes. I think it's a continuance.
It's a continuance, but you skipped it.
How did I do that? Is my thing out of order? One.
Oh, on the paper, on the electronic version.
Oh, on this one, it's not in that order.
Ah,
So this one it is, okay. All right,
that's what.
well, no, that's, I'm on this one. That's after.
Sorry, it's out of order on our
Page 6.
page, that's why.
What did I skip?
Page
Clark.
You didn't.
Oh, it isn't? Oh, it's on
last.
Oh, I'm sorry, I'm looking at the
On
electronic.
paper, you're right. The right
Page.
sequence is.
Okay,
Attorney Schultz is here just to seek a continuance.
Can we just, can we do the?
okay, we can go to that. All right. Where is that in here? Appeal number 2025-006, James D. Clark and Christine D. Clark have appealed an administrative official's decision. The petitioners are appealing the notice of zoning ordinance request for enforcement denial dated January 24th, 2025 under MGL Chapter 48, Section 7. The petitioners submit that the decision of the administrative official dated January 24th, 2025 was in error as the structure was erected at 968 Main Street is not a pole supported by wires/rope and burlap. It was constructed by 4x4 lumber cemented into the earth, extending approximately 20 feet into the air directly on the common property line, draped with burlap, which encroaches at 978 Main Street. The subject property is located at 978 Main Street, Katuitt, Mass., as shown in Assessor's Map 034 as parcel 032. It's located in the Residence FRF zoning district. This was continued from March 25th, 2025 and April 9th, 2025. And members were assigned myself, Herb Odenseek, Paul Pinard, Mark Hansen, and Rodney Tavano. Attorney Schultz, how do you want to proceed?
Oh, good evening, Chair Dewey, members of the board, Michael Schultz on behalf of James and Christine Clark. Just respectfully seeking continuance until May 28th. I've spoken to Michael Gill, who's the title holder, the abutter. He hasn't appeared. He's not going to appear this evening, and he assents to the continuance to May 28th.
Okay.
Want me to make a motion?
Building Commissioner Florence, will you be able to be here May 28th as well? If this is, yeah, okay. Or it'll be remote. All right, so does someone want to make that motion?
Yeah, I'd like to make a motion for appeal number 2025-006. Clark, continue to May 28th, 7 PM.
Second, Paul.
All those in favor?
Aye.
Aye.
Thank you very much.
That is continued. Thank you. All right, so back to appeal number 2025-007. Victoria McCloskey, Cynthia Foster, and Mary Curley have filed an appeal of an administrative official's decision in accordance with Chapter 240-91, non-conforming lot of the Barnstable zoning ordinance. The appellants are appealing the decision of the building commissioner and issuing building permit BLDR 25-14 dated February 7th, 2025, issued to Michael Martin and property owned by TL Acquisitions LLC. The appellants state the building permit should not have been issued as the premise is not a valid non-conforming lot under Section 240-91. The premises lack required legal frontage and access to the private way, and the project fails to comply with the zoning ordinance requirements applicable, including special permit. The subject property is located at 933 Main Street, Osterville, Massachusetts, as shown on Assessor's Map 117 as parcel 187. It's located in the Residence C RC zoning district. This was continued from April 9th, 2025. Herb was acting chair at that time and did assign the members present. No testimony was taken. So I'd ask the applicant, would you be okay of us assigning members that are present here tonight?
Yes, we would
Okay.
like to go forward.
Okay. Okay. For the record, Paul Pinard is recusing himself. So that will leave our regular members, myself, Mark Hansen, Manny Alves, and Rod, do you want to sit on this? Sure. Okay. All right.
Great. For the record, Jack McElhenney, attorney, representing the Foster, Curley, and McCloskey families who are abutters to this project. This is an appeal from a building permit issued on February 7th for Cottage I at 1033 Main Street in Osterville Center. The property is located in a RC district. It's designated on the plan of record as Lot D, containing 21,592 square feet in a district where 40,000 square feet is required. The property owner has, as of February, raised the 880 square foot cottage, which was located on the lot, and is replacing it with a 4,200 square feet home, which is under construction, notwithstanding the appeal, notwithstanding our letter of February 26, notifying the property owner of our intention to contest the legality of the construction. And of course, you know, the central issue here is the lot does not have the required 40,000 square feet to be a buildable lot within the RC district, and therefore its eligibility for a permit depends entirely on its qualification as a legal, pre-existing, non-conforming lot. This is really a tale of two lots, and one of which we acknowledge was legally existing, pre-existing, legally non-conforming, and entitled to protection. And the second lot, which was appended to that small 8,000-foot lot in 1999 and more than tripled the size of the project. And you see behind you a compiled plan put together from the exhibits to my application, which shows this is the Gallery Place neighborhood, so-called. Many of you are probably familiar with it. It consists of 10 small cottages built sometime, perhaps even prior to 1970. They share a common driveway. They share a set of common utilities, and they are subject to a set of common restrictions. None of the lots has any frontage on any public way other than the common driveway. And as these lots are private lots and it's a private way, the property line extends to the center line of that private way. 8 of the 10 lots are under 5,000 square feet in size. You can see from the plan 3850, 4300, 4100, 3850. These are the size of the lots. Mary Curley, who's here, one of the neighbors, her home is 500 square feet. So this is a unique property within the town of Barnstable, I would suggest, and has a lot of history. To get to the nuts and bolts, the development parcel, which you see outlined in red there, is at the very end of the common way. It was created by combining parcel B1, which was 8,600 square feet, with a larger 12,000 square feet lot, which was never part of the Gallery Place Trust. It was not named in the original declaration of trust, and therefore it has no rights, in our opinion, to use the common driveway. It has no legal right to use the common utilities. That's black letter real estate law, that an easement only benefits the specific, detailed, described lot, which is the benefited parcel within the easement. And there's really no dispute that the second parcel, which I referred to as the appended parcel, was never part of the trust property. So as stated, the lot does not clearly meet the 40,000 square foot requirement and therefore is unbuildable unless it can meet the requirements of your bylaw, Chapter 240, Section 90, subsection 8. That section was added in 2005, and to qualify for the safe harbor, Lot D, the development lot, must be a pre-existing non-conforming lot and must meet certain minimum requirements as to front setbacks, FAR, and lot coverage. And we believe that the property fails to meet that standard for 3 specific reasons. First, and to me, the most clear-cut violation is that the lot which is being built on is not set back 20 feet from the front lot line, as is required by your bylaw. The bylaw specifically says that the front setback is the distance between a street line and the front building line of a principal building or structure. As shown on this plan and on the building plans, there are 16 feet setback. I don't know the reason for that on a 40,000 square foot lot, but obviously this is a major imposition on the neighbors and is, the pre-existing cottage was 11 feet in height. The new structure, 32 feet in height. So it looms over the abutters, and I think the analysis of its eligibility for protection is critical. Secondly, even if the required setback is met, the lot still has to be a legal, pre-existing, non-conforming lot. And that while there's no dispute that this lot predates the adoption of 240-90H, but it has to be a legal non-conforming lot. And here we get into the weeds a little bit on zoning law, and I apologize for that. The good news is that the leading case in this area is the case of Mendes versus Barnstable, which involved the Rogers and Marnie property up in Osterville. And it stands for the proposition that a lot which gains its buildable status by virtue of the grant of zoning relief is not considered a legal non-conforming lot, which is therefore entitled to the protection of the statute. In other words, it already has special dispensation, and you cannot piggyback on that special dispensation to continue to avoid the otherwise applicable requirements of the zoning ordinance. It is acknowledged a very tricky area of the law, and I would suggest that a discussion with town council about the applicability of the Mendes decision to this, and the fact that there is a 1999 special permit for this property already is critical fact here. That special permit needed to be amended in order to authorize further construction on this property, in my opinion. Secondly, and I'd ask the board to indulge me for just a second, I would like to read to you quickly, and it is short, the language of the one relevant paragraph of your bylaw, which is 240-90, Section 8H. And as you listen to this, ask yourself, which of the two lots does this bylaw refer to? Does it refer to B1, which was laid out as part of the original subdivision and had 8,000 square feet, and on which the cottage was originally constructed? Or, as the building owner argues, does it apply to the much larger 21,000 square foot lot? So here's the language of the bylaw, which protects pre-existing non-conforming lots. We say pre-existing legal non-conforming lots which have been improved. So it's not referring to vacant lots. Pre-existing legal non-conforming lots which have been improved by the construction of a single or two-family residence which conform to all provisions of the zoning ordinance at the time of construction. So you're looking at the lot that existed at the time of construction. Such a lot shall be entitled to completely demolish the old residence and construct thereon a new residence in accordance with the following. And it then lists setback requirements, FAR, lot development. And I would point out, it's critical when you're talking about FAR and when you're talking about lot development that you know what the lot is and what the bylaw intended to be protected as a pre-existing lot. It makes perfect sense for a small lot that was built legally to allow it to be replaced, but you can't extend that immunity to a lot 3 times its size and then calculate floor area and lot area based on this much larger lot. For instance, this project under construction today, the FAR, if you looked at lot B1, which I believe is the only lot which has non-conforming status, the FAR would be over 50%. So it's a critical question. Finally, and this is more of a general comment, but I think an important one given the purposes of zoning, et cetera. The larger parcel, the appended parcel, if you will, was never part of the trust. It never had rights to use the utilities. It never had rights to use the access way. It was created from land which came from the back of the subdivision. Therefore, legally, and there's a pending Superior Court case on this now, legally, that back parcel has no rights to connect to the utilities in the private way, no right to use the private way for access. This plan shows portions of the structure, a large swimming pool, the septic system, and the driveway on land, all on land, which was never part of the trust. And for these reasons, the board should overturn the issuance of the building permit and require that a special permit or a modification of the 99 special permit be issued, and pursuant to which, and I think this is the heart of this, the criteria is whether the new home is substantially more detrimental to the neighborhood than the existing home. So that is the analysis that was avoided here by taking advantage of this, I believe, bootlegged argument that this entire 3 times larger parcel is entitled fully to immunity as a non-conforming lot. Thank you. Any questions?
Thank you. Is there any questions?
Yeah, I do.
Sure.
Actually, a few. If, and I take your word, that legally this new lot that's proposed to be built upon does not have access to any of the utilities that are part of the trust, how would it be serviced?
I think that's a question for the town. And whether or not, there's safety issues here. Again, they were already connected. They were already constructing it. But there's a lawsuit pending in Barnstable Superior Court saying, yes, you could connect Lot B1, which was 8,000 square feet, but you cannot connect 21,000 square feet. You cannot add a new 4-bedroom house to our water line, which already there's a low water pressure issue in the neighborhood. And again, all of these lots share common expenses. They have a budget, they share the landscaping, they share insurance, they share snow plowing, et cetera. And they all have shares that are roughly based on their proportionate size. And yet this has come in now, which is, literally 5 times the size of both of the adjacent parcels. And it's not paying its fair share. So that is going to be addressed by the court. But it's also an issue of safety. I mean, if the court were to rule, which I believe they will because I believe it's black letter law, that those utilities do not benefit the back parcel and that access doesn't, then everyone's got a big problem, including the town, because, there's not going to be utilities to this. So,
And thank you for that. One more question. So the question of pre-existing legal lot here, the pre-existing part means in existence prior to the adoption of zoning.
prior to the adoption of the relevant section of the
Of the zoning bylaw.
for which you are arguing you're immune.
Agreed. Whatever you're proposing to rely on.
Exactly.
Got it. So is it your point, if I understand it correctly, that the combined lots upon which it's being proposed to be built did not exist prior to this ordinance being in place?
It existed, but it existed by virtue of a special permit, and therefore
I get it.
its zoning validity was dependent on a special permit, which at a minimum should be amended. That would be the proper road forward in my position from a zoning perspective.
Got it.
That case, by the way, dealt with the combination of those lots and then the reduction in the size of a lot that was already non-conforming. So it was a lot that had 26,000. They went in for relief, and again, this was still a 40,000. They went in to get relief, and this board allowed them to reduce it to 22,000 by virtue of a special permit. But with that relief, it's not legally, it didn't exist but for this board's action blessing it. And that puts it in a different category than something that simply was created under the applicable laws without relief.
That's the Mendy's decision.
That's the Mendy's decision in Austinville.
Thank you.
Any other board members? Go ahead, Mark.
Just a quick question. So just again, for clarification, so outside of the special permit, this would normally be merged. There would be no issue here, but because it was formed under a special permit, this is where the back lot can't be connected to the front, even if there were no utility there, let's say.
What's that?
Even if, I mean, I see a pool, but let's assume there were no utilities there.
Yeah,
No
I
use
think
for
those are two
utilities.
separate, from a zoning point of view, I think you're right. If this lot had just pre-existed and they added to it, and they could have done that under zoning,
We obviously see this a lot, right? We merge lots to account for the FAR and things like that, but.
Sure.
So you were purporting.
I think
that-
this is an extreme example of a set of facts which allows someone to replace an 800-square-foot cottage with a 4,200-square-foot home. And, you know, I think if you read the bylaw carefully, you'll see that the lot, of the two lots, the lot that was protected was only parcel B1, which was the one on which the cottage was originally constructed and was a legal, non-conforming lot at that point. And that immunity did not extend to the second lot.
So you're saying at minimum, there should have been an amendment to the special permit?
Right, which would have required this board to make a determination of whether the proposed use is substantially more detrimental to the neighborhood than what was there. And again, you know, it's the whole law of non-conforming uses, that they are entitled to exist, but that they are an exception, and their modification should be carefully scrutinized.
Thank you.
Any other questions?
Yeah, I have a question. So you said in your appeal something about the premises lack the required legal frontage, and the legal frontage should be 20 feet?
No, the premises lack the legal frontage in the sense that the bulk, 2/3 of that property, in my opinion, has no rights to use that private way. They were never part of the trust. They never were granted easement rights to use that. They have no rights to use those utilities. So although they may have physical frontage, you know, on that private way, legally, the back 2/3 of the lot don't have it. Now, I don't mean to suggest that a fire truck is ever going to stop and not go around to the back of the house. But if the court rules that they don't have that, there's going to be a problem for everyone here.
Yeah.
Your second point, the 20 feet, is even if you qualify as a legal, non-conforming lot, you still have to meet certain basic
Yes.
zoning dimensional requirements, one of which is that you have to have a 20-foot front yard setback. And your bylaw says that is measured from the street line. And the distance from the street here, which is the private way,
Yeah.
to the front of this house is 16 feet.
Right, it's not 20 feet, that's for
It's
sure.
not 20 feet.
No.
To me, that's black and white.
Yes, no, I saw it today. It's not even close.
Yeah.
I even think 16 is an exaggeration, but, okay.
Thank you. Any other questions?
Are we good? All right. Attorney Sabat, did you want to, or Building Commissioner, do you want to speak first, or it's up to you? Okay. Yeah, if you want to give us a background. And
Good evening, Mr. Chairman, members of the Zoning Board of Appeals. Again, Brian Florence, your building commissioner. That sounded really complicated and convoluted. However, it's really quite simple. What you've heard from Mr. McCluskey is the issues at hand are, it's a large building, it's looming, the neighbors don't like it. You've heard that the use of a driveway is a zoning matter. It's not, it's a property dispute. You've heard that there's a trust property and a right to use that and allow utilities over it, and not paying their fair share is a zoning matter. It's not. That's a civil matter between parties. The Zoning Board of Appeals decision that was referenced is 1999-95, and the ZBA found that the merged parcel then owned by McQueen was a pre-existing non-conforming lot. Mr. McCluskey will tell you that the special permit was a merger that made this a legal non-conforming lot. But if you look at the special permit, it says the petitioner is applying for a special permit, non-conforming lots, to permit the conveyance of 159 feet by 25 feet rectangular portion of the subject property to 3 of the northern abutters to this strip, which will increase the nonconformity of the subject lot by reducing the area. He wasn't combining the lots through the special permit. He was granting a piece of the lot to the neighbors. And so, to me, I'm looking at a special permit that was granted. It didn't merge the lots. It granted a piece of the parcel to somebody else. So that puts me squarely in 24090 non-conforming lot provisions. And if you look at the intent of that, 24090 says it's the intent of this section to protect the property rights of owners of pre-existing legally created non-conforming lots, uses, and buildings or structures, and to provide regulation of changes or expansion of pre-existing non-conforming structures, buildings, and uses. So the intent of it is to protect pre-existing non-conforming lots. So if we're protecting a pre-existing non-conforming lot, we have to look at the provisions for demolition and rebuilding of a parcel. And so does the town allow for that? When you get to 24091H, it does. You can demolish and reconstruct a property as of right. The proposed demolition and rebuilding shall be permitted on a pre-existing legal non-conforming lot, contains at least 10,000 square feet of contiguous upland, provided that the building commissioner determines that all of the following criteria are met. The structure conforms to all current use and setback requirements of the zoning district it's located in. The setback from the property line needs to go from the property line, not the road that goes across the easement. So when you look at the 20-foot setback, it is setback at least 20 feet. Then the building commissioner must find that the proposed construction conforms to the following requirements of lot coverage, floor area, ratio, and building height. We did. We found that exactly. So we found that the lot coverage does not exceed 20%. We found that the floor area ratio does not exceed 30%, and that the building height is less than 30 feet from the top plate. So, Mr. Chairman, members of the Zoning Board of Appeals, I would submit to you that the building department, me specifically, the building commissioner, acted judiciously, responsibly, and reasonably in evaluating the review of that property and the demolition and rebuild of the property under 24091H, and we did our job appropriately, and we ask that you uphold our decision.
Don't go yet.
I'm not going to.
Because I have a question.
Go ahead.
I guess factually, I'm hearing two different things. What I came away from the prior presentation was that decision in 99 created this lot. You're saying that special permit actually made it smaller by allowing for the conveyance of a piece of the then existing lot. Is that right?
That is correct, and it's right here in the special permit. The purpose of the special permit was to convey a piece of the parcel, not to merge it. It merged by virtue of the fact of ownership. When you buy two parcels.
Which was Mark's point, I
Yeah,
thought.
when
right?
you buy two parcels and they're undersized, they merge for zoning purposes. So it merged. It was a legally non-conforming lot at the time.
And the special permit that I heard.
1999.
Yeah,
Yeah.
the prior speaker talked to not legally serving as the basis for conveying pre-existing non-conforming status to this is actually that special permit was not creating the lot, it was allowing for it to be stripped, part of it to be conveyed out.
If the mechanism to create a nonconformity was based on a special permit, that would be a problem. Mr. Kluski's right. But that's not what this was for.
Gotcha.
It merged on its own, and a portion of it was excised later.
Thank you.
Anyone else have questions?
Thank you very much for your
Okay,
time.
thank you, Commissioner. Attorney Sabat, did you want to speak?
My name is Charles Sabat. I represent the permit holder, which is TL Acquisitions, and I wanted to say that we clearly agree with the building commissioner that the building permit was properly issued. And let me echo, if I can, the building commissioner's comments on the 1999 decision that was rendered by this zoning board of appeals. And before I do that, let me point out, I don't know if you had a chance to read my letter of April 4, but these lots, B1 and what they call the added-on lot or the appended lot, were merged at least as of 1954. Because I show there's a plan of record where this lot, both what was previously the back lot and B1, were owned by Mr. and Mrs. Marston as of 1954. They had acquired all of the property on that plan as of 1950, and at least as of 1954, they acquired the back parcel. So those two parcels were merged for years, decades, before 1999, before they came to the Zoning Board of Appeals. The provision that they came in here for in 1999, the owner then was a Ms. McQueen, Jessie McQueen, who owned these merged lots, which was now a single lot, came in under a section of the zoning bylaw which exists today. And that section says, no lot or a portion thereof may be changed or transferred in any manner that will increase the degree of nonconformity unless a special permit has first been obtained from the Zoning Board of Appeals. And what that addresses is that under zoning, if I have a pre-existing nonconforming lot and I make it smaller by segregating out a piece of it, in other words, I divide off a small piece to give to a neighbor. Let's say a neighbor wants some additional land. I give him 1,000 square feet. I have now undermined the nonconformity, the legal nonconformity of my lot. So in order to prevent that from happening, our bylaw provides that you may come into the Zoning Board of Appeals and get permission to reduce the size of your pre-existing nonconforming lot and slice off a small piece to give to a neighbor. That is exactly what happened in 1999. This decision did not create a nonconforming lot. It confirmed that these merged lots were in fact nonconforming. The decision itself made that finding. So the board has already found that these merged lots were nonconforming. They say the subject lot, I'm reading from the decision, is currently nonconforming with regard to lot size, being 0.57 of an acre. So that finding has been made. That finding was made in 1999, and what happened here is that if you look at the plan that is a part of that decision, Ms. McQueen was allowed to slice off, to divide off 3 very small lots, or a little bit of a dogleg. And interestingly enough, 2 of the petitioners in this proceeding who are objecting to this permit benefited from that. They actually own those lots that were divided off and have been combined with their own properties on this private way. So I'm a little baffled by that argument because, if anything, that decision confirms that this is a pre-existing nonconformity. The building commissioner is absolutely right about that. In terms of the frontage, they made an argument in their submission to you that somehow, because this easement, this private way, crosses over my client's property, that somehow that undermines this as being a lot, and that's not the case at all. A lot is defined as a single parcel of property that is not bisected by a street. Bisection, and I've defined it in here, means you cut it in half. That doesn't happen in this case. What's happened here is my client owns right to the front property line, subject to an easement. He has the title to the land over which that easement travels. And that easement is not a street line. They come in here and they argue that this is a private easement, it's a private way, and that my client doesn't have the full extent of the easement rights because Lot B1 was combined with another parcel back in 1954. Well, you can't have it both ways. It's either a street or a private way. This case is a private way, and setback is determined from a street line. Now, there is no definition of street or street line in our bylaw, but a street is owned by the public, by the town of Barnstable. In this case, the easement that crosses my client's land is owned by, he owns the land. These people only have rights to cross and recross his property. So you don't measure a setback from an easement line, you measure it from the front lot line, which is exactly what the building commissioner has determined, and I would say that he's completely correct on that point. In terms of whether or not my client has an easement or not, doesn't have an easement across this property, first of all, we submit that he does. The issue here is there an overloading of the easement by virtue of the fact that as of 1954, the front piece, B1, was combined with the rear parcel to make up this single parcel. And the building commissioner is correct. That is a matter for private adjudication by the courts. They're in Barnstable Superior Court now, opposing this project. That's where that decision will be made. And that doesn't really affect zoning. That's not really a matter of zoning, the extent of my client's rights over that private way. That is a matter of easement law that must be determined by the court. And if nothing else, they acknowledge that my client has an easement to lot B1, if nothing else. So he has an access to that property over that right-of-way. And the same would be true on the argument of the utilities and the water. That is not an issue for zoning. Zoning goes to area, setback, and the like. It does not go to the question of whether or not a lot is properly serviced by utilities or not. And we say my client has a right to access those utilities, and he has a right to have electric, he has a right to have water. But again, that is not an issue for deciding by either the building commissioner or by the zoning board of appeals. So on the zoning issues that they have presented here, this is a pre-existing non-conforming lot. The 1999 decision did not create this lot. It confirmed that this was a pre-existing non-conforming lot. The building was properly demolished. It meets the setback requirements properly determined by the building department. It has sufficient lot frontage. There is no bisection of this lot under our bylaw. This is a valid lot. This permit has been validly issued, and I would ask you to uphold the building commissioner. Thank you.
Thank you, Attorney Sabat. Does anyone have any questions?
Just quick clarification on the frontage. Is that normally calculated on the road frontage? I'm just asking rather than the property line frontage.
Okay, so lot frontage is determined by well, actually, we don't have a definition of lot frontage, but what can give us some guidance is that a lot is a single area of land in one ownership defined by meets and bounds or boundary lines, no portion of which is bisected by a street. Bisect means to cut in half. That's the dictionary definition of the word bisect. But frontage is determined by the distance between the two side lines. So if I have a front property line that is, whatever it is, 50 feet long, measured from the two sidelines, that's how I determine the frontage of my property. Does that answer the question?
It does. Where it gets, I think, convoluted is because it's a private way. So normally, if it was a street, the frontage would be calculated on the circle.
Right.
Okay.
So if I have an easement, if I could just address that, as I said a moment ago, if I have an easement, if you have an easement over my property, let's say that's 20 feet wide, you have rights to cross and recross under that easement, but I own the property. I own what we call the fee underneath that easement.
I understand.
That's the difference.
I understand. I'm just asking about the calculation of road frontage and how that's happening, but it is different when it's a private way. Okay. Thank you.
All right. Thank you. Thank you.
All right, so we still need to open this for public comment, so I'll make a motion to open for public comment.
Second.
All those in favor?
Aye.
All right, so we're open for public comment. If anyone would like to speak to this, just come up and say your name and address for the record. We did not receive any correspondence, I don't believe. And nothing else came, oh, and it's not here. Jenna, did anything else come in? No? Nothing, okay. All right, if you want to speak, just come up to the microphone and introduce yourself.
I'm the immediate neighbor to the back of the property, Robert Savage. I'm on 69 Meadowlark. The current time I'm recovering from recent cancer surgery, and I'm living through dust and dirt and construction noise and horrible music every day. It's not really exactly a peaceful environment. So my main short-term question, I'll leave the other questions up to the lawyers, is since the proper buildability of this structure is in dispute, why is it allowed to be continued to be built until the dispute is resolved? Because in the meantime, it is disrupting the peacefulness of the neighborhood. And also, it seems to me, just in common sense, the more that a giant, expensive building like that gets built, the harder it is for people to have the courage to say we're going to knock it down because we determined that it wasn't legal at the end of the road. Thank you.
Thank you. Anyone else have any comments or questions? All right, so if no one else, I'll make a motion to close public comment.
Second.
All those in favor?
Aye.
Aye. All right, so public comment's closed. The public hearing's still open. Does anyone have any thoughts or questions, or? We have two attorneys of the building commissioner here.
So we have to uphold his decision, right? Is that
We either uphold his decision
decision
yes.
or not, or decline? Okay.
Overturn. Yeah, come on, yeah, you can come up and.
I'd like to just respond very
Yep.
briefly to Mr. Sabat's comments. I think two points, and I agree, this is very complicated. I encourage the board to reach out to town council and get their views on it. The first is, if this is a private way and not a street, where is this lot's frontage? That's question one. Second question, I think I want to clarify, is just semantics. I have said that this lot, which is 22,000 feet, was created via the special permit. That's correct. There were 4 lots involved in that transaction. There was a 26,000-foot lot, which was reduced to 22,000, which is the lot in question. So the 22,000-foot lot, which is the one the building permit is pulled on, was created by the 1999 permit. And secondly, the issue is not about whether it was non-conforming before or after. The question is about the Mendes decision, which says when you have a lot which exists by virtue of the grant of zoning relief, then that lot is no longer a generic, pre-existing, legal, non-conforming lot, because it only exists, and I'll use that word, it exists, it was created by virtue of an action of this board. Again, you need to read, not you, but it's the Mendes case. It went all the way up to the appeals court. Mr. Ford, who was here earlier, was probably in his 30s when he argued that case and won. So it's...
So let me ask you a question on that point. To you, it does not make a difference that, in fact, that decision made it more or less conforming?
No, not at all.
In other words,
You know, once this board touched that lot and blessed that lot, even though it was reducing its size, that lot lost its status as a legal, pre-existing, non-conforming lot, and the proper method for moving forward is to amend that special permit.
you heard your brother say that, in fact, the only way to achieve the conveyance, to make it less conforming, was to come from the board. It becomes a catch-22.
Yes,
right?
it does.
Because
Yeah.
they couldn't make it less conforming unless the board approved it, because it was already
It's
non-conforming.
the fact of the approval and not exactly what occurred in that approval, which makes it fall outside of the safe harbor of being a legal, pre-existing, non-conforming lot. It's complicated. One of the few areas is Section 6 of 40A in which the Supreme Court has undertaken to rewrite the legislation.
No, I read the Mindy's decision. With all due respect, that's not what it says. It doesn't talk about merely touching it. It's creating the lot that causes.
By virtue of that, in that case, it was a variance, yes.
Right.
Yeah.
But it created the lot.
No, that actually dealt with a use. It was a pre-existing use. And yes, it was a pre-existing woodworking type of use, which was converted, and the court, and they tried then to use the non-conforming status to say, well, we're entitled to expand or modify this without going through the current bylaw. And the court said, no, this is not a pre-existing legal non-conforming use because of the grant of zoning relief which created it. So
Wait.
that's my opinion.
I hear it. Thank you.
Okay.
Does anyone else have any?
Just, go ahead.
I'm not really sure. Sorry. I'm not really sure where I'm at with this. I don't know. What's everyone's thoughts?
Well, you want to go first? Go ahead.
No, where I'm struggling is that this lot was merged in 1954. It obviously existed this way for quite some time, the 1999 decision. I don't know how that, it's like asking for it one way and then asking for it another. You know, whether or not, and even if you get further down into this, as far as, you know, is it more detrimental to the neighborhood, things like that. I mean, it's tough in Osterville to say anything built large is detrimental to the neighborhood. I can understand why in this particular scenario it might not be, you know, preferable. And, but I'm having a hard time understanding really the true legality of why that is not why it is not subject to the rights of that first lot.
Yeah, I think I'm where you are. Until the comment just made, that just by virtue of the fact that a decision of this board affected this property, that caused it to lose its status as pre-existing legal non-conforming. To be honest, I hadn't thought of that, but it would seem to me that the party at the time had one option. It had a non-conforming property, and the zoning ordinance requires, if you're doing anything that makes it less non-conform or more non-conforming, you need to get zoning relief, and that's what they did. And I guess I don't see how, having done that, that caused the property to lose its status as if anything, it became more non-conforming, but it was pre-existing by virtue of the merger of the lots in the 50s. So I'm inclined to uphold the commissioner's decision, but there's a legal question there, and I thank you for raising that. I mean, if that is in fact, if just by virtue of having a decision of this board affect that property caused it to lose its status, it seems, I'm not convinced, but
I was trying to think of another thing that we've heard that would be similar to that, where a special permit did in fact reduce the ability to use the lot in any particular way, or that there were any given rights as far as access or things like that. I'm struggling to think of anything. It doesn't mean that we haven't. I just we usually, when we see these, we're usually trying to unmerge lots, not merge. You know, this thing was merged so long ago. I just don't understand how that would have changed it.
So does someone want to make findings, or we still haven't closed the public hearing?
I could do it.
Do you want to make findings? All right, so I'll make a motion to close the public hearing.
I'll second.
All those in favor of closing the public hearing, no more testimony can be taken.
Aye.
Aye.
Aye. Are you for closing the public hearing?
I am. Sorry. findings. So this is on appeal number 2025-007. Make sure I have the right property. Yeah, yep. Victoria McCluskey, Cynthia Foster, Mary Curley have filed an appeal of an administrative official's decision in accordance with Chapter 240-91, non-conforming lot of the Barnstable zoning ordinance. The appellants are appealing the decision of the building commissioner in issuing building permit BLDC BLDR-25-14 dated February 7, 2025, issued to Michael Martin on property owned by TL Acquisitions LLC. The appellants state the building permit should not have been issued as the premise is not a valid non-conforming lot under Section 240-91. That the premises lack required legal frontage and access in the private way, and that the project fails to comply with the zoning ordinance requirements applicable, including special permit. The subject property is located at 933 Main Street, Osterville, Mass., as shown on Assessor's Map 117 as Parcel 187. It's located in the Residence CRC zoning district. Based on the evidence we've heard and the testimony of the building commissioner and the presentations of the attorney representing the parties, I would find that these properties merged by virtue of common ownership back in the 50s. And as noted in the decision from 1999, at that time, this board found that the property was, and I'm looking at finding number 6 of that decision, the property is a non-conforming with respect to minimum lot size. And so I would find that the property here was not created in 1999, but in fact, that decision in 1999 only went to the approval of a disposition, a conveyance of piece of the lot outward. And again, based on the evidence we've heard, I would I'd be inclined to vote to affirm, to uphold the building commissioner's issuance of the special permit. I do not find that this board somehow, by approving a special permit to allow the conveyance of a strip of that property, deprived it of its legal pre-existing non-conforming status. So I would be inclined to vote to uphold the building commissioner's decision.
So what about in regard to the legal frontage? Like what are we calling the frontage?
I think is,
What is the front and the side and the rear of it?
well, the evidence we heard from the building commissioner is that it exceeds the minimum required. And I know there's a question about, do we measure it relative to the street or the private way, but I guess I'm persuaded that the premises do have the required legal frontage.
Mr. Chair?
Yep.
The board is simply here to either uphold or overrule the issuance of the building permit. And that's it.
Not,
I think we're entitled to have that point addressed to preserve the record on appeal.
well, thank you.
I look at the staff report and we've got 1, 2, 3 on the staff report. 1, the premises are not valid non-conforming lot under Section 240-91, which you just addressed. 2, the premises lack required legal frontage and access rights in the private way. So that's what I was just asking you
Yeah,
to address.
but I guess it's implicit in upholding the decision, we're upholding all the findings made by the building commissioner, which I guess is Anna's point, right? So to the extent we're saying we're upholding the building commissioner, as is required to, went through all the requirements in the ordinance and found it proper to issue the permit. So in upholding it, we're implicitly, I guess, agreeing with
Saying
his
that there's
findings.
legal frontage.
Right.
Okay.
that would be my findings. I appreciate the fine legal point raised, but I'm not convinced that again, merely by allowing splitting off of that property, that the board's decision, as I said, deprived it of its pre-existing non-conforming legal status. So, those would be.
Second, or does anyone?
I'll second that.
All right, all those in favor? Approving?
I'm in favor of that.
Favor?
I'm going to abstain. So we've upheld the building commissioner's decision. All right, I will grab Paul for 2025-012. And I'm going to abstain myself from that item.
You read the staff report. And then this.
Okay, it should be noted that
Oh, no, where's Jake?
Jake has recused himself from this, and I am back now on the board.
Oh,
This concerns appeal number 2025-012, Zig Harbor LLC. Zig Harbor LLC has applied for a special permit pursuant to Section 240-92B, non-conforming buildings or structures used as single and two-family residences. The applicant proposes to renovate and restore a pre-existing non-conforming single-family dwelling. The scope of the work includes lifting the house and pouring a new concrete foundation to replace the existing foundation with alterations and updates to certain windows, dormers, entrances, roof decks, and porches. A special permit is required due to a portion of the proposed alterations occurring within the 10-foot rear setback. Subject property is located at 100 Washington Ave, Hyannis, Mass. As shown on Assessors Map 287 as parcel 116, is located in the Residence F1 RF1 zoning district. The members assigned to this case will be all the members that are here. Hi, go ahead.
Hi.
Identify yourself, please, and proceed.
Thank you. For the record, my name is Attorney Patrick Nickerson. I'm an associate at the office of John W. Kenny, who's here to my left. Also with me in the audience is Kevin Dauphinais, the architect on the project, along with Carolyn Tenney, one of the principals of Zig Harbor LLC. So the subject property is located at 100 Washington Ave. It's shown on your screen, outlined in blue. If you're looking at it, you might think there's not a lot of space to the rear setback, which is precisely why we're here before you this evening. This property was constructed in approximately 1900, which would predate zoning. Zoning in Barnstable began in 1929. It has a very close rear setback. It's presently a foot back from the rear lot line. The LLC is looking to restore this rather significant property. It is of local historic interest. A photograph of its front facade is shown here. By lifting the house, pouring a new cure-in-place concrete foundation, setting the house back down, as well as touching each side of the house, making alterations and updates throughout, mostly like in kind with what's existing. The proposed scope of work has received the permission of the Barnstable Historical Commission unanimously. So it speaks to the tastefulness for which these updates are being considered. Specifically, the westerly carport is being removed and rebuilt. The southerly entry porch is being removed and rebuilt. The easterly sunroom is being removed and replaced with a renovated kitchen. The northerly shed porch roof is being removed and replaced with two smaller entry porches that's the area for which we need zoning relief. If I could show you the amended site plan we filed, I will describe the issue that we've run into, which brings us here this evening. Let's see if I can zoom this in. The existing rear setback is a foot from the deck measured to the rear lot line. You can see that there is the shed roof over this deck, which is being removed and replaced with a smaller entry porch. The smaller entry porch should be visible in just a moment, with a new improved setback of 3.1 feet. So the existing degree of non-conforming rear setbacks being improved such that the 1 foot rear setback is being increased to 3.1 feet. Ordinarily, alterations and expansions to legal pre-existing non-conforming structures can be done as of right, except where encroachments are being entered into a 10-foot side or rear yard setback. This is the case despite the fact that we are lessening the degree of nonconformity, increasing the rear setback from 1 foot to 3.1 feet. If you're crossing that 10-foot red line, so to speak, on the rear side, we have to come before you for relief. And the standard for you to consider this evening is whether the proposed new dwelling is substantially more detrimental to what's presently existing. I submit to you that it's not. We're reducing the degree of nonconformity of the rear setback. There is a very modest increase of height as a result of the cure-in-place concrete foundation. The existing height will increase by 14 inches, but that's well within the allowable height under the ordinance. I'm happy to answer any questions you may have. Thank you.
So just a couple of quick ones. Who owns this as what we're looking at now? Who owns the property to, I guess technically the north? The one that's right here that shows no dwelling or smaller?
This is 112 Washington Ave. This is also owned by the LLC. It is improved by a detached garage with living quarters on the second floor.
And were they bought at separate times? They haven't been merged at this point?
We don't believe they've merged because the principal dwelling predates zoning, being constructed in 1900. The rear structure appears to be constructed in a similar period of time. Both lots being developed, we feel that both lots are entitled to develop lot protection, or at the very least, we're not looking to hash this out on this application. The question really is to whether the proposed expansion and alteration of the principal dwelling at 100 Washington Ave may proceed as a special permit. I will disclose to the board that our client is proposing to return regarding alteration to the rear dwelling in the future. But right now, those plans are still in progress, have not yet been finalized, and are not subject to our current application.
If I may further respond, both lots were developed prior to the zoning coming in with the living quarters in that garage. Developed lots don't merge.
So it wasn't purchased, and then they weren't purchased at the same time, or they were?
Well, the plan dates back to 1872.
Oh, Jesus.
The parcels involved with 100 Washington Ave were also issued in 1872. The parcel to the rear is actually an unnumbered lot, meets and bounds description dating back to 1902.
So it doesn't have an address?
It has an address of 112 Washington Ave.
Oh, I'm sorry.
They're assessed separately. There is a driveway extending back to 112 Washington Ave. I could pull back up that memorandum. I can show you the
I only asked the question, and I understand where you're going with it. we had a situation where there was kind of owned that way, and it was basically separated so that it could be developed and then sold. So
These have been separate since 1902.
I understand, sure.
Manny? Yes.
Yeah, just, you mentioned that the height will be increased, but would still remain within,
Absolutely.
The limits.
We're allowed 30 feet to the plate, and we are well below that.
so you're not doing it as a right because of that 10-foot.
Only because of the 10-foot rear setback. That's correct.
But we're tripling the setback.
From 1 to 3.
Any more questions?
No, I think it was fine. I didn't realize it was on the street. I didn't realize you had to go through the one get to the next.
It is a good point, and one we'd just like to save for another day.
I understand.
Okay, thank you. I'd like to open this now for public comment. Anybody here like to say anything? Seeing none? Oh, yes, please. Please come up and identify yourself.
Hi, I'm Carolyn Tenney, and I just want to say that we're keeping that all together. That's the backyard, so to answer your question, Mr. Hanson, we have no plans on giving our backyard to somebody else. Okay.
I understand. I saw when I saw the topographical, it made a little more sense. I
Thank
just
you.
was sensitive to it.
Yes, wait a moment. Recognize Town Councilor Lutke.
Yes, thank you. For the record, Betty Ludke. And I live fairly close to this property, and I've watched this house, I guess, since I was aware, after being born, that it existed. It's an absolutely gorgeous property. You see it when you come in on the ferry from Nantucket or the Vineyard as you come in.
Mm-hmm.
I have spoken at historical commissions. I think all of these houses that kind of frame Fort Beach there are just treasures. And I admire Carolyn for taking this on. It's an enormous project, and I've seen the drawings. I love what she's doing. To keep it just where it is, maybe a little bit higher, is what we want. I mean, I'm not speaking to the zoning stuff. I'm just speaking for the character of a place, and for someone to take on a project of this size and do it as beautifully as she's proposing to do it. I admire it, and, you know, I would approve this. I can't see, like she just spoke, she would never sell that back. That's the backyard. So it's always been like that, always been like this. As we heard when it was built, it has an historic presence, and it's absolutely gorgeous. Thank you.
Okay, can we, let's see, do you have anything more to say?
No, thank you.
All right, I'd like to close public comment.
Second.
All in favor?
Aye.
Aye. Bring it back to the board for discussion.
Yeah, my only concern would have been, how they were going to deal with any sort of like trespass. I didn't realize it was co-owned. I'm assuming that there's no view easement on the parcel behind the backyard parcel, as far as going up in height or anything like that.
Well, it's still under 30 feet, so, okay?
Yeah.
Any other comments for the board? We ready to findings? Who wants to have findings here? This is an easy one. Thank you, guys. Okay, wait a minute, I'll do it.
You do it?
I'll do it if I can find it. All right.
I don't have it in front of me.
Okay, sure. Manny?
All right, so this is on special permit number 2025-012, Zig Harbor LLC. The applicant has applied for...
Mike, is your mic on?
Thanks, Dave. The applicant proposes to renovate and restore a pre-existing non-conforming single-family dwelling. The scope of work includes lifting the house and pouring a new concrete foundation to replace the existing foundation, with alterations and updates to certain windows, dormers, entrances, roof decks, and porches. Special permit is required due to a portion of the proposed alterations occurring within the 10-foot rear setback. Subject property is located at 100 Washington Avenue in Hyannis, as shown on Assessor's Map 287 as Parcel 116. It's located in the Residence F1 RF1 zoning district. I would find that the application falls within a category specifically accepted in the ordinance for a grant of a special permit. in Section 24094B allows for a special permit. After an evaluation of the evidence presented, the proposal fulfills the spirit and intent of the zoning ordinance and would not represent a substantial detriment to the public good or the neighborhood affected. There's been no public comment in opposition. In fact, we've heard support for the proposed project. And the site plan review is not required for single-family dwellings. And I would also find that the proposed alteration will not substantially be more detrimental to the neighborhood than the existing building or structure. It will be an improvement to the property as opposed to a detriment. And as described, I would find that to just conform to the language of the ordinance, it will not substantially be more detrimental to the neighborhood than the existing building or structure. Those are my findings.
Also, Ed, didn't the Historical Commission approve this?
Yes.
Yeah, I wanted just to note that for the record.
And Mr. Alves, I heard you say 24094B?
92.
92, thank you.
Right. Sorry, maybe I misspoke. I apologize. It's 24094B.
92.
92B. I misspoke twice. 240-92B.
I guess I can avoid my hearing test this year. Thank you very much.
Getting late for me.
Let's, how do you, wait, do you have a second on those findings?
Second.
Okay, all in favor?
Aye.
Aye.
Okay, do you have conditions?
Yes.
Yeah, I'm sorry, do you have conditions, Manny?
Yeah. The conditions are numbered 1 through 5 in the staff report. Have you had a chance to look at those?
Yes, we have, and they are acceptable. Thank you.
So I would suggest that the conditions numbered 1 through 5 in the staff report dated April 24th, 2025 would be my conditions.
Second.
All in favor?
Aye.
Aye.
You have it.
Thank you.
Thank you very much.
Congratulations.
Good luck. There's a lot of work to have done on that one, I saw. Okay, I want to note, correspondence, Jake?
You're fine, you can take it.
Jake is here, he's here.
Oh, okay.
Note that we have 7 items of correspondence from the, 5 from the Cape Cod, 6 from the Cape Cod Commission, and 1 from the Housing Assistance Corporation. Are there any matters here?
One just quick, did anyone get a chance to meet on this pool and other thing group, or did that happen? Or?
Yes.
Okay.
We met with Jim. And
The end of March, actually.
yeah, and they were going to go back and work with the building commissioner and draft something, but Paul was there, I was there.
I was there?
Yep, yes, you were.
So it's moving along in some form?
Yes, well, I thought of that the other day, but I didn't know if it was protocol to ask Jim what's going on or not.
Okay. So Jim was working on drafting something based on
Jim
their
was
feedback?
working on drafting something and then run it
Yeah,
by
he's very
legal.
Yeah.
Okay. No, we don't have a legal.
Okay.
Without a legal department.
Are there any matters? No, seeing none, not anticipated? Okay. Upcoming hearings are the 28th, which is the next one, if that's remote, June 11th in person, and June 25th remote. How's the agenda looking for those? Are they going to be biggies? Filling up? Okay. Okay, great. Have a motion to adjourn?
Second.
All in favor?
Aye.
We're out of here. Thank you.